So welcome everyone to this next program for Berkeley Law. You're here with Berkeley Center for Law and Technology and our Expert Series webcast. We have, again, two great experts with us today. You've heard me before when we start talking about issues on cybersecurity. The West Coast doesn't have as many experts as the East Coast. So the great thing about this format is we can go find the experts wherever they are. And we've got two here today that were willing to volunteer their time to talk with us. First, it's my first time with Brandon Wales. Brandon really has an incredible position when it comes to cybersecurity. I think you're the first executive director. Is that right, Brandon?
I was the first executive director at the Cybersecurity and Infrastructure Security Agency, and I'm now vice president of cybersecurity strategy at SentinelOne, a cybersecurity company where I focus on helping companies improve their cybersecurity strategies.
So when you look at that breadth from government expertise to company expertise, it's pretty incredible, and I appreciate you joining us here today. And with us from Morrison Foresters, one of the partners from the DC offices, Joe Folio. Joe is one of the litigators, kind of the senior level trial lawyer at Morrison Forester, focusing on a lot of privacy and data security litigation. And if you look through his extensive list of clients through the years, you'll see a lot of hands-on experience, and has kind of grown with this practice as it's become more prominent to the legal world and more regulators in it. So with the two of you, I think we get to see the entire growth of this practice and kind of where we are today. But you're here specifically to discuss something that is an incredibly hot topic, and that is executive orders and cross-border data transactions, something that is, I think, haunting many in-house counsel these days. And if it's not, it probably should. So with that, I will turn it over to the two of you, and I look forward to this discussion.
Thanks so much, Wayne. So we'll start with a story. So in 2019, the New York Times published an expose, and it was entitled "The Privacy Project." And one of the more prominent articles in that project said 12 million phones, one data set, zero privacy. And basically what the New York Times did was they went out and they purchased and processed an quote unquote anonymous data set. And by manipulating that data, they were able to determine, among other things, which people worked at the Pentagon, which people worked at the White House, who visited Mar-a-Lago. And by looking at other information, such as what doctor's office did they visit, where did they worship, they came very close and were able to, but didn't take that step to identify who those individuals were. So I think in a nutshell, the executive order that we're going to focus on today was intended to address those issues. So on February 28th, 2024, President Biden issued this executive order entitled "Preventing Access to Americans' Bulk Sensitive Personal Data, and also to United States government-related data by countries of concern." The executive order directed the Department of Justice to issue regulations implementing the executive order. And then the DOJ recently issued the final version of these regulations, and they go into effect on April 8th, 2025. And because the EEO is premised on a law called the International Economic Emergencies Act, there are civil and criminal penalties for violations. So this is a really, sweeping and unprecedented regulation, and we're all trying to understand what it means and how it's going to be applied. And I think our goal today is to sort of walk you through a little bit, first, the background, how did we get here? Second, give you a basic 101 of the regulations to make sure we're all on the same page and have a basic understanding of what they are and how they might apply. Third, to highlight really some of the knotty issues that people will probably be struggling with. And then finally conclude with talking about what's next. So, Brandon, I know obviously you come from the government and you were there as these things were coming out. Do you maybe want to give us a little bit of a background of the genesis of these regulations and what they're intended to do? Oh, Brandon, I think you're muted.
I'm still learning Zoom in the private sector here, Joe.
Yeah.
So I think you highlighted it right. The challenges and potential risks to Americans of the access to their data, given how much data is collected by modern technology, I think is fairly staggering. And I think as the government was looking at this challenge, what they saw was an environment where more and more data was available, more and more data was being shared and moved around from company to company through data brokers and in other ways. At times, it was ending up in the hands of countries that are not friendly to us. And the government did not have, I think, sufficient tools to address those risks. And not to say that they had none, not that they did not work in certain places. I mean, we've had long-standing privacy rules related to health information through things like HIPAA. But kind of the comprehensiveness was missing, and became clear that obviously Congress was not going to move ahead with any type of broad federal privacy law, something akin to GDPR in the EU, and so the executive branch, I think, moved forward with this executive order, which uses the IEPA authority, which is fairly narrow because it has to be tied to some kind of critical international nexus. And that is why it focuses on how do we limit the availability of sensitive data on Americans going to countries of concern. So it doesn't deal with all federal, all data privacy issues. There is still going to be a lot of data about Americans moving around to a lot of companies within the country. And there may be concerns with that, but the government doesn't necessarily have the authority to deal with that at that scale. And so it is focused on this question. I think the other critical point is, in some cases, the government has been able to restrict some of these data flows, but it tended to be in very isolated cases where it had an opportunity to enter into very specific national security agreements with companies that come before the Committee on Foreign Investment in the United States, or they're applying for a license with the FCC. They want to own some telecommunications or an undersea fiber optic cable. And when those cases come before the government can require through an agreement that companies will agree to limit the amount of data that can flow about Americans to an upstream, for example, parent company, or a new investor overseas. But again, not comprehensive, very ad hoc. You only had a limited number of cases to do that. And so DOJ, kind of the prime mover behind this, said, we want a way to be able to deal with this at the scale of the challenge today. And I think that's where you found this executive order and the subsequent regulation emerge.
No, I mean, that's consistent with my own experience. So before I came to MoFo, I was the chief counsel for the US Senate Homeland Security and Governmental Affairs Committee, and we were looking at these issues and we were struggling with trying to figure out how to deal with them. And to your point, the existing procedures like CFIUS were whack-a-mole, right? It was one at a time, and maybe you addressed the problem, but it was only one in an ocean of issues. And my sense is that the executive order is a recognition that the lack of regulation, that to many people is enjoyable, has just frankly swung too far, and it started to venture into the world of national security risks, right? And those risks became so great because this is data, as you noted, that is being literally sought out by foreign adversaries, that the executive stepped in and used some of its existing authorities to act. I think when I think of this, I think that at bottom, right, this executive order is motivated by national security concerns, right? Like that's why we're talking about it. But it's really a focus on data security and privacy issues, including how you define what counts as sensitive data and what security requirements you need to put in place. So it really does bring in all these different disciplines and try and address a variety of issues.
And Joe, I think we can get to this, but I do think it could force companies to really think about the exposure that they have of the sensitive data on Americans, and how do they limit it as much as possible. And although, as you note, this is really focused on countries of concern, those covered entities, and limiting those flows, I do think it is an opportunity for companies to think about, are they protecting this data sufficiently given the amount of concern that there is both among the public and certainly in policymakers, that there's just too much of this sensitive data floating around, and more needs to be done to keep it tightly controlled.
Yeah, I mean, in our prior conversations, you described it really well, right? You said it's treating your data as an asset, right? And understanding where is it? Where is it going? Who has access to it? And are they misusing it?
Exactly.
I think that the other interesting thing, which you touched on, was just the fact that and this is a little more from the legal perspective, right, that it emanates out of IEPA. It's an executive order, and I think some people were, surprised. They said, "Oh, the president issued an executive order, and then that means people are going to go to jail." And the answer is, well, yes. But the sort of like legal underpinnings are right that there are actually two underlying statutes, right? There's the National Emergencies Act, so the president had to declare an emergency. And then once declared, we're hearing more about this in the news today, the president gets a key chain of authorities, one of which is IEPA, and it's through those two statutes that they've issued this regulation. And as you noted, IEPA really is the underpinning for the U.S. economic sanctions program. So I think that by the president invoking that program, they were trying to rely on the experience and expertise of using IEPA as the underlying statute. So it's not to say that everything is going to be the same. Of course, this is a new branch on the tree, but at least it's something they're familiar with and people are familiar with. So I'm very curious to see how this progresses, especially once DOJ gets implementation. And Brandon, I know you have thoughts on this. So the fact that the DOJ is the one issuing the regulations, what do you think about that?
Yeah, I know it is certainly going to be interesting. DOJ does not have long experience in the regulatory space. They obviously have a lot of experience in terms of going after people for criminal compliance issues and investigations like that. So they have a lot of capability, but regulating like this is going to be new for them. And I know that they were staffing up a team that was going to be focused on implementation and execution of this regulation. But there's going to be growing pains as they get to understand how to execute their regulatory authority under this new rule, and as companies begin to interact with them. DOJ has a lot of tools if they get you in their sights. So I do think that there's going to be a high burden on companies to really be thoughtful about their compliance with this new regulation, because I would not want to run afoul of DOJ in this case.
Yeah, indeed. All right. So the last sort of subtopic I have on my list for like the background section is, well, we've got a new administration. This, executive order actually came out from President Biden, federal regulations issued under President Biden. What changes, if any, do you expect in light of the new administration?
Yeah, I know it is a super interesting question. I think that there are elements of this that kind of are extremely bipartisan. The concerns around how foreign nations, particularly countries like China, might misuse data on Americans for both national security and other intelligence reasons. So I do think that there is likely going to be a strong push within this administration to keep and move forward with this. They have an opportunity now, but before implementation, they could potentially look at kind of implementation and enforcement. But it has not been. I've not heard anything in the near term about them re-examining this. So I would count on this moving ahead because there is, I think, a greater willingness to agree with and move ahead with national security related regulations. In the first Trump administration, those did not have the same scrutiny that non-national security regulations did in deregulatory pushes then. And I would imagine that's likely to be the same now.
Yeah, we said it the same way. This is largely a bipartisan issue. Insofar as there are differences, differences seem to be around the margins. It's probably something that would be more likely to influence enforcement priorities as opposed to a wholesale rewrite of the rules. We say that in part, I think, because, well, we had the pleasure of Devin DeBacher, who is the head of the DOJ section that wrote and is implementing these. We hosted an event in which he spoke about these rules, and his assessment was this is bipartisan, is not going away. He also told us that they are staffed up, so they have a team of attorneys that are ready to go on this. So they're not starting from zero. And I think right now, at this moment in time, he has been appointed by President Trump to be the acting head of the National Security Division. So right now, all signs point towards still a go. There was an executive order that addressed other executive orders. There was a category of rules that have been promulgated but not yet entered into force, which this falls into. The only thing it said was consider whether a 60 delay is appropriate, but certainly no requirements. So I think by all accounts, one way or another, this is going to go into force. And all eyes, I think, at this moment are on April 8th. All right, should we dig into a little one-on-one on what the regulations are?
Yeah, definitely.
So so I've been working from the PDF version as opposed to the CFR version that came out, but the PDF version was 421 pages, not all of which were rules, but it was a lot of commentary. So really just a lot to digest and store out here. And the way that we've been thinking about it, we've boiled it down to just some basic questions that companies and people can ask themselves to start to get a sense of whether this law applies to them. And sneak preview, the law applies much more broadly than people tend to think. So first and foremost, you have to ask yourself, are you a US person, right? Because the executive order and the laws by definition can really only apply to places where the government has jurisdiction. So what this law restricts is US persons, US companies doing things with sensitive data. So once you've gotten past that initial test, which again may be very complicated if you're a multinational corporate organization with lots of subsidiaries, you're really going to have to do the unpacking of the corporate structure to understand the entities to whom the law applies and to whom it doesn't. Question two is, once you've got the US persons, do those US persons have what the rule referred to as covered data? And when we talk about covered data, and we'll get into this more with the examples, the two big buckets are bulk US sensitive data, which has lots of sub-buckets, but then also US government related data. And once you make the analysis that you have this kind of data, the next question is, do you provide access to that data? And access is defined very broadly in the regulations. And it's not just the sale or transfer or the official licensing, but if you literally make that data available, if someone in a subsidiary who is not in the US has the ability to see that data, that counts as access under the rule. Once you've determined access, then you have to start assessing to whom you've given access. And as part of that analysis, you will determine, are there non-US persons, non-US companies getting that data? And are any of those non-US persons covered persons or countries of concern? So that's when we get to countries like China. But I think people shouldn't lose the very important interim step. This regulation has requirements. If you take your sensitive data and you make it available to non-US persons, full stop. So for example, if there is a data exchange in the EU, obviously not a covered person, not a China, not a Russia, but you nonetheless make it available to that data exchange in the EU, that is a foreign person, and the regulations require you to take certain steps, such as amending your contracts, to require your counterparty not to onward transact that data to a country of concern. So this is the place I think where people can get caught up. I don't do business in China. This doesn't apply to me. The regulations are part of that. Anyways, the final question we would ask is, once you've gotten through all these steps, you have sensitive data and you're making it available to non-US persons, and especially if it's a covered person, does an exemption apply? And there are a whole list of exemptions, and they would apply depending on your circumstances, et cetera. So that's the sort of high level summary of the way we're thinking about it. We could get in obviously spend the entire hour, if not longer, on any one part of these. Brennan, any part of that you want to spend a little more time on or highlight?
No, I mean, I would take it up a level and talk a little bit, I think, what are the major principles that kind of underpin, all of this that I think companies need to have in the back of their mind as they're going through the analysis that kind of you just laid out. I think overall, the goal is, how do you prevent access to data by countries of concern? And I think that is going to require companies to understand their data as an asset, where it's going, who has access, at a level of understanding that probably is not there today for most governance, risk, and compliance teams. And so I think that's where doing that type of analysis is critical, and it's going to require this kind of entity by entity analysis. For each of my contracts who may have access to sensitive data, what do I understand about them, their ownership? Do they count as a covered person? And how do I stay on top of it if there are changes? And then I think last is this idea of knowing your data and knowing your vendors. What kind of regimes do you have in place to ensure that you have confidence, so that if DOJ comes with questions subsequent to this rules implementation, you have the tools necessary to answer their questions, and that you have defensible positions around the investigation you have done, the analysis you have done into your data, its availability, and who has access, and what you understand about the companies and interparties you may be working with that have access to your data, even if it's not transferred wholesale. And I think those principles together, I think, put a lot of responsibility on companies to get into the weeds on their data and their contractual relationships that probably is far beyond kind of normal due diligence for most companies today.
Yeah, I mean, I think I mean, from the data side, right? Like there's the concept of like data mapping, which is easy to say, hard to do. So I think that this is, as we've just mentioned, an opportunity for people to engage in that. But it really does require knowing your data, right? Like understanding really what data do you have? Because some people may not realize what they're collecting and may not realize that it hits some of these triggers. And then what are you doing with your data? Where does it go? And I know from the financial world, you say KYC, people know exactly what that means. But I'm not sure that everyone that deals with this type of data, especially because the definitions of data are so broad, have that same level of familiarity. So these are those principles I think that some people may loosely know, but will have to get familiar with very quickly.
Yeah, so I think you're right. Like the idea of, in the financial world, KYC is common, but every company who has data arrangements with foreign partners doesn't have the same type of regimes in place. And for large multinational corporations, as we talked about, could have thousands of contractual relationships. Understanding who has access to your data, who doesn't, if they do, what data do they have access to, all of that type of data mapping that's going to be required. And understanding those vendors it just raises the bar on what you have to understand and the amount of due diligence you're going to have to do.
I think also, I mean, it's easy to say like, let's do a corporate analysis or let's map your data. But I think it's also going to be an awakening about the difference between what these things look like on paper and what they look like in practice, right? Like how tight is the alignment between your corporate structure and your data structure, right? Do you have subsidiaries and affiliates and everyone knows where it is and they're incorporated separately, but at the end of the day, they're on the same workday. Or you don't even know who has access to it. And I think that's, even once you map, I think this will be a living sort of breathing effort. Like you might figure out that things are more interconnected than you realized at first, or that it looks like on paper.
Yeah, I think this is an issue where not your compliance, but the compliance program you're going to have to implement to be able to monitor this as an ongoing basis, I think is an order of magnitude over what companies probably are likely expecting.
Great. So, should we dive into the issues?
Yeah.
Okay. All right. So I think the way I was sort of like teeing this up for you is like, just in general, just saying the response when they look at these data regulations to say, these don't apply to me. I don't have operations in China. Is that a get out of jail free card, Brandon?
Yeah, I mean, I think that's going to be kind of the key question. There are multiple countries in this list, like Cuba, Russia, Iran, North Korea. A lot of companies, because of a lot of other sanctions in place, probably don't have a lot of either relationships or operations in most of the countries that are covered by this regulation. China is going to be the significant exception to that. So you do not have to have, as you noted and at the beginning, when it comes questions related to access, you do not have to have operations in China to have potentially covered individuals accessing your data or transactions to happen, because you need to understand kind of the ownership of the companies that you are transferring or giving access to data to. You need to understand if they are, if potentially, and again, this is, I think, some of the areas that we're likely to see kind of shake out as implementation and additional guidance is, what does it mean if it's a European company, but they exclusively use programmers or engineers located in China, or a joint operation located in China? That appears that could potentially be considered covered, depending on how exactly that is structured and how the scale of individuals that are being used there. There are also specific designations. You can have individuals that are specifically sanctioned or identified by the U.S. government as covered individuals, and you're going to have a program to ensure that as those new individuals get designated, that both you and those companies that have to have certain you have to have contractual language in your new procurements to cover that they don't transfer that data or make it accessible to these specific individuals. I think as we have seen a rise in the U.S. government specifically sanctioning entities involved in the Chinese IT space because of their cooperation with Chinese military and intelligence services, there is likely to be a growing number of those specific designations that are out there, in addition to whatever ones that that are done because of broader data privacy issues. But I think the initial answer is I don't have operations in China, I don't have to worry, is absolutely not going to be the case here. There is still a lot of due diligence you're going to have to do because of the questions related to ownership and location matter heavily in this kind of entity by entity analysis that you've got to do to understand where your data is going and how it's being accessed. And also the reason, and we can talk about this in a few minutes, but the way in which you move data, the reasons matter, and the way you document why you're making certain data available will become critical to how you demonstrate compliance with the rule.
And we didn't spend 20, 30, 40 minutes going through like how the rule operates, right? But there are in short different types of transactions, right? So you have the bucket of prohibited transactions, which are transactions that you can't get involved in at all if they involve the sensitive data and they basically crest the bulk threshold. But then the whole other bucket of transactions is restricted transactions. And these are transactions that you are able to engage in with sensitive data so long as you follow certain security requirements. And the three types of restricted transactions are vendor agreements, employment agreements, and investment agreements. And that's, I think, kind of what you were getting at, right? Is that like, do you have vendors? And if so, do you know where they're organized, like where are they incorporated? Do you know their principal place of business? Do you understand whether they would rise to a covered person because they're owned, by a Chinese conglomerate? And that may not be obvious if they're not located in China. So I think that's the level of diligence that people aren't necessarily thinking about, right? Because the law is not, like, the definition of covered person is not based on someone's nationality. It's basically based on whether that person is someone subject to the authorities of these countries of concern, right? So you can imagine if someone's residing in China, then the answer is yes. If they're incorporated with the laws of China, yes. Or if there's ownership interests. And the ownership investment agreements, those attach at any investment, right? There are some exceptions for passive investments, 10% or less. But if you have Chinese minority investors, that could make someone, potentially an investment agreement to which the restricted transaction requirements would apply. So I think that there is a lot of detail and certainly a lot of devil in the details. And then, of course, as I mentioned earlier, I think even if you're doing this assessment and you determine that the person is not a covered person, just the mere fact that they're a non-US person, you have that requirement under Section 302 that says, okay, you must amend your contract to include provisions making them promise that they won't onward forward your data to a country of concern. So at the least, really anyone who's operating internationally is probably going to need to do at least that. And as you said, right, compliance programs to make sure, like, do I venture beyond that? Do I, the next day hire a Chinese vendor and didn't realize that because I didn't have the compliance program? So it really is going to be a dynamic environment.
Yeah, and there's the other provision that requires you to notify DOJ within 14 days if you receive a request for potentially covered data. So again, now you have to have an entire regime where in the company, if you get those requests anywhere, you are affirmatively reporting it to DOJ. So they have awareness of specific entities who are interested in covered data. Again, just kind of layered on top of that, even if you don't do operations, if you get a request from a company who's potentially operating in China for certain data, you now have an obligation to take an action.
And that 14-day requirement applies to the onward transfer contract. If there's a violation of that, there's also 14 days. And, certainly my transition to the private sector, I've seen that, like, larger companies, right? Like, sometimes it takes time for information to percolate up within individual companies, let alone to, wherever you're organizing your compliance effort and reporting obligations. So 14 days is fast. It's, can be easily missed if you don't have the right triggers in place.
Yeah, Joe, why don't you talk about data broker? I mean, I think people, when they see the executive order, thought that this was really about large scale data brokers, and it didn't really have to do with kind of the more mundane data that ultimately I think is covered by this rule. We're talking about relatively small amounts of data on individuals, like 1,000 or more, in some case, records on Americans, if it contains certain data like financial, would be covered. How does it apply? How do companies think about their role as a data broker?
Yeah, not? I think that people read that word very naturally and have the reaction that I'm not a data broker. But as the rule describes it, right, this rule applies to first-person data brokers and third-person data brokers. So I think everyone thinks of data brokers as the third person, right? Someone that collects data directly or indirectly, but then they're in the business of selling data. The rule certainly encompasses that, but it is much broader. The first, as they describe, first person data broker is literally, do you have sensitive data? So if you collected data from your customers and you make it available to others, you're not even selling, you're making it available to others, you are a data broker. And just to spend a minute on the definition, it says the sale of data, licensing of access to data, or similar commercial transactions involving the transfer of this data to another person. And the DOJ spent some time in the commentary. They put up 3 versions of the rule and took comments and responded to them. And as you can imagine, a lot of the comments focused on what does this phrase mean, similar commercial transactions? And basically it boils down to, is there any consideration? Like, is there any monetary value, even notional, being exchanged? If so, you're regulated. The one example the Department of Justice gave in its commentary that fell outside of it was when researchers were exchanging data for the purpose of writing an academic article. That was it. So the DOJ has acknowledged that it is purposely defining words like access and data brokerage very broadly because it intends for this rule to apply very broadly. So I think that's where a lot of people are getting caught up too. They think data broker, that's not me, and they kind of move on, and they're probably doing that too quickly. Should we go to the next topic?
Yeah.
All right. I think this is probably the trickiest. When we do the entity by entity analysis, and we know that there's a restricted bucket for vendor transactions, I think that's where a lot of people are going to get caught up. It's like, what do I have to know about my vendors? What do I need to be doing? What should I be doing? What are the requirements? So I think we're going to spend a lot of time talking, beyond this call about, what is a vendor transaction and what diligence is required. Do you want to start, Brandon?
Yeah, and I think the question related to, as you already started to talk about before, the level of understanding of ownership, citizenship, residence of is kind of at the core of this entire rule related to what is a covered entity. And so it's going to require that. And I also think it's going to require companies to really think about what their contractual language is that covers the obligations of those companies who have access to their data on both reporting things that might be covered by this, but also on restrictions on what they can do. And also to be able to monitor changes in the practices of those companies. Again, I continue to go back to, there are a lot of questions about how this rule will treat companies who are hiring large numbers of individuals in countries of concern, or your data maybe moved to those places to conduct additional analysis or work or whatever that may be. That due diligence now is going to fall on these American companies to ensure that if these things happen, that they are at least aware, can report it to DOJ, and then stop it at their end. And so the ability to both put in place protective regimes up front by contractual restrictions, and on the back end, what kind of monitoring and compliance looks like, for every contract. And I think that there are a lot of ways in which companies are going to think about how they implement this rule. Do they restrict their data so it's not available to as many foreign entities and contractors and vendors? Are they going to put in place the security requirements if they think that they're having this kind of data, but they need to continue it for critical operational needs? Do they limit the number of foreign vendors that they use that have access to American data and use more onshore companies for those kind of things? It I think is going to require that level of kind of both due diligence, but also thinking through what is the most efficient way of implementing this regulation while also being able to effectively conduct your business. I think those two things need to come together in some way to say, how do we limit the data movements as much as possible, so that we can continue to execute our business's overall mission.
Yeah, and as you said, especially if a company has not 2 or 3 vendors, but 2 or 3,000 vendors, right? Like, that's a lot of work to do. And I think that it's kind of an open question about what diligence will be required or expected. If you go under the DOJ microscope, the rules do contain, as part of the prohibition section, specifically rules that prohibit evasion, and also rules that talk about whether or not you're knowingly directing things. So there's a lot of emphasis from the DOJ about whether you're knowingly avoiding a regulation. So basically, they're trying to impose liability not only when you do something, actively do something that violates the rules, but also if you put your head in the sand, right? Willful blindness. So if you had reason to know what you were engaging in was a covered transaction, but you put your head in the sand, they will still consider you to be liable for violations. So when we think about this from like the vendor context, it's really like two levels, right? It's like knowing your vendor, like who is your vendor, right? Like they may be not in a country of concern, but do they have ties to a country of concern? And then it's knowing what does your vendor do with your data once you give it to them. And some people may have no idea, right? I mean, does that vendor turn around and send your data to a country of concern, right? Are they putting it on a cloud service based in China? So there's certainly an expectation that you will be having these conversations with your vendors. And then I think the details are going to be what conversations do you need to have, right? We know on one end of the spectrum that if they're a foreign vendor, that they're going to need that contract provision, right? We know if they're a foreign vendor in a country of concern, it's going to be a restricted transaction and we're gonna have to apply all those security requirements. But really it's kind of like the in-between that we're sorting out. And I think one of the examples that sort of like drove that home to us, actually, there's like really two examples that doesn't really answer the question. So the question is, if you're doing your analysis of your vendor and you look at your foreign vendor and you realize that they are not located in China, for example, they are not organized under the laws of China, and they are not owned majority by China or another covered person. You seem like you're in the clear, right? So the rules would have you analyze that person and say, this entity is not a covered entity. But what if that vendor employs one person who resides in Beijing? What if that entity employs 100 people who reside in Beijing? Doesn't make a difference. And the commentary and the rules address this issue obliquely. They use the one person example and they say, you have an agreement with a non-covered foreign entity to give them information. They have an employment agreement with a person based in Beijing. The rules don't apply to the vendor talking to that one person. And you're like, okay, great, that's thanks. But what does that mean for me? The DOJ is kind of quiet. The other example, they say if you hire a vendor and that vendor is primarily staffed, even though it's not covered because they're based in Europe, but then they're primarily staffed by people based in Beijing, you should know and you will be liable. And you're like, okay, well, I got that. So where's the in between?
Yeah, and I think that's where you get back to like the principles. Like the idea is to keep your data away from countries of concern. So it's not just like, as you know, like one data analyst at a company who may have access, but if this is really a European domiciled company, but they outsource all of their team to a country of concern, that's violating the kind of core principle upon which this rule was really based around. And so I think companies need to have that in their mind as they're kind of doing this analysis, that how DOJ is going to interpret evasion, whether like you did a wink and a nod while you hired a European company, but it was really a masquerade for a large team in China. That is not going to put you in good standing. But I think more broadly, the amount of work that's going to be needed to kind of document not just your conclusions, but kind of the decision-making process and the analysis that you've done, and the steps that you've taken to address potential risks in implementation of this rule, I think will be extremely important in terms of compliance regimes.
Yeah, I totally agree. My sort of last thought on this is that as we think about what is a vendor agreement, I think this, the rules, the revised final version of the rules went out of their way to make clear that a vendor agreement is something that is distinct from data brokerage. Data brokerage is the prohibited transaction. So it sort of puts them on a spectrum and says, this is data brokerage, this is a vendor agreement. And I think there's going to be a little bit of effort about trying to sort out which is which, because obviously if one is prohibited and one is allowed to proceed but restricted, you can imagine people would want to maybe lean that way. There's also the middle, or the donut, as we've been calling it. Sort of, well, what is in the middle? Is there anything in the middle, given the broad definition of what a vendor is and what a brokerage transaction is? And if so, what does it look like? Is it just the researcher example, or is there something else? So I think these are all issues that, again, look fine on paper, but we're going to spend a lot of time trying to sort this out.
Yeah, that may be a unique area that companies ask about, and maybe get eventually some implementation guidance from DOJ to help reconcile those. We know that they don't want everything to be counted as a data brokerage agreement, to kind of put everything kind of in the prohibited bucket. But kind of squaring that circle with some of the definitions that it has around brokerage could be challenging. And so I'm assuming this is one of those areas that could, over time, get clarified by DOJ in guidance put out to the community.
Are we good? Are we good on vendor
Yeah,
data?
let's move on to geolocation data.
Yeah, so I've been thinking about this one a lot. So geolocation data is one of the 6 types of sensitive data, and we didn't go through them at the top, but just to sort of tick through them now, you have human omic data, which includes genomic, but also more, biometric identifiers, personal health data, personal financial data, personal identifiers, and then precise geolocation data, right? And all of those have bulk thresholds, right? It's got to be 1,000 biometric identifiers or 100,000 covered personal identifiers.
Yeah.
But then in the second bucket, that's the US sensitive data bucket. In the second bucket of regulate data is the government related data. And I think there is an instinct for folks to look and blow by this bucket and say, this is not me. I don't deal with government data. It doesn't apply. But one of the 2 types of data in there is geolocation data. And that precise geolocation data has nothing to do with whether or not you are the government or you have government contracts. It has only to do with whether or not you collect precise geolocation data. And the reason why, gets back to the New York Times article we mentioned at the top, is concern that if you have precise geolocation data, you can determine whether or not people work at government facilities. So what the regulation has done is that it has put out a list of over 700 geolocation areas of government facilities and said you cannot collect and then engage in data brokerage transactions with precise geolocation data of these locations. So if you are in the business of collecting precise geolocation data and then transacting with it, right, this restriction applies to you. And I think this is one that is maybe not catching people's eyes, at least at this moment in time.
Yeah, and it's one that could change. I think as noted that is not a static perpetual list, and it will be updated over time. So companies will need to, as part of their compliance, understand if they're putting in certain blocks related to those areas with collecting data, is that sufficient? Will they have the program in place to make sure that they're continuing to update that as DOJ may make some updates? But yeah, that is one that I think is going to cover any company that is collecting geolocation data inside the United States is going to be impacted by that, regardless of the level of detail that they're doing it at.
It's going to be like the sanctions list, and companies have developed procedures to make sure they're constantly checking the list and they're running that across their customers and their vendors. So I think it's going to be the same issue. From a technical perspective, Brandon, I don't know if you have thoughts about this. Like, I guess like the 2 ways to address this, right, would be like front end, right, like sort of like geofence, like disallow, like don't collect data from these 700 places. I guess you can also do it on the back end too, right? Like if you do collect data and you're going to transact with it,
Rub it out.
you're like, yeah, I don't know. Do you think one way is better than the other? Or?
I think a lot of it will depend upon how that data needs to be used or processed by the company in terms of how they would set up their systems to. I could imagine that there will be different types of companies who are using that type of geolocation data in different ways, who may need to do more of the analysis at the edge, and they may collect it ancillarily, but it can never really be fully collected because it can just be done in an app, let's say, and it doesn't necessarily need to flow back to the company's servers. But other companies who are going to be using data, that kind of geolocation data for processing, they may have to keep it for a while. They may want to scrub it in terms of whatever data is then shared on with potentially covered individuals or with any of their foreign counterparties.
Mhm.
But that will be a key issue for any company that's collecting geolocation data. One, kind of mapping how they're going to address this, but then putting in place the technical regime that would either address this risks up front by just not collecting it at all, or putting in place certain restrictions around how it moves.
Yeah, exactly. Well, speaking of restrictions, I'm a company that engages in restricted transactions all over the place. I have covered investors, covered employees, of course, covered vendors too. So now I've wandered into this world. I have to apply the CISA issued security requirements. There are also DOJ final reporting requirements. My very layperson's assessment is the emphasis here is on the word restricted. But Brandon, how do you interpret these security requirements?
Yeah, I mean, they're comprehensive. So when I was at CISA, I was involved in our efforts overseeing the development of these. I left after the NPRM was issued, so was not there when the comments came back in. They did not change substantially, so there's been a lot of consistency between the NPRM and the final rule on these. And I will say that there are parts of this that are fairly intensive. I mean, there is a requirement that you are verifying data flows in an audible manner for any restricted transaction so that you can have certainty that that data is not flowing places that it should not. And so again, putting in place a technical regime to do that. When it comes to some of the requirements, the security requirements on any system that may be involved in restricted transactions, I would put these in kind of two buckets. I put these in maybe three buckets. There is um, a set of requirements that have to do with overall level of security on your system, any system that does this. We're talking, and the governance regime on top of that. So do you have basic organizational policies and programs in place? Do you have an identified leader who's responsible for execution of your security responsibilities, such as a CISO? Do you have a vulnerability management program? Do you have an understanding of your network and have developed the network topography, et cetera? Then I think there is the kind of technical things, the technical controls that should be in place. And these track very closely back to the NIST cybersecurity framework and the CISA cross-sector cybersecurity performance goals. And they're kind of what you would expect for any type of cybersecurity related requirements, things like multi-factor authentication and configuration management to avoid people who should not have access to data having access to the data, um, you know, implementation of zero trust in a variety of ways and identity management, et cetera. So I think a lot of that is going to be, I think, standard for many of the large companies who this will probably be affecting because they, in a lot of cases may have to go through some of the same type of frameworks to ensure SOC 2 compliance or others. But you're going to have to do this an in-depth analysis to support specifically the systems that may be involved in restricted transactions. I think the thing that was relatively new, certainly for CISA, and then the requirements in here are some of the data level requirements that are required. While I think NIST in the past has promulgated things like a NIST privacy guidelines, they don't have as much underpinning as the NIST cybersecurity framework does. There is not this, long history of developing a lot of special publications that companies can look at and say, I understand here are all the controls that can go into effect. But things like applying data minimization and data masking strategies, there's a lot of ways in which you have to think about tackling that. And that's where I think the process that you're going to have to go through, do the analysis about which of these makes the most sense, why I made the decisions that I did related to this data becomes extremely important. Even going to the point of talking about the different types of encryption regimes that you might use associated with your data, the key management associated with your data, using new privacy enhancing techniques that help preserve privacy while sharing some underlying information. There is a lot that a company will have to go through as they think through what their strategy is to implement these requirements that have been put into place. And as we talked about earlier, I think when you think about a couple of different ways of implementing this rule, if you are going to be engaging in these transactions, your analysis of your approaches to sharing data are going to have to fundamentally be evaluated and potentially changed. I think today a lot of companies probably make more of their data available to more people inside of the organization then might make sense, particularly if you're in a large multinational corporation that has pretty seamless flowing of data across borders. You're going to have to take a much harder look at that, particularly if you have entities that might have, where you may need to make restricted transactions with covered entities. So I would encourage companies as they're beginning to kind of go down this road, that how they bring together their security team, their general counsel, and their operational teams to make sure that this time and they're obviously their IT teams to make sure that this can actually be implemented and these controls are put in place while still allowing the business to operate. Could take some work, and the clock is ticking on implementation. So like the sooner they start on this, the better, because it will take time to work through the analysis and, if necessary, put in place what might be new security controls, new privacy controls around the data that they have.
Also, just from a practical perspective, I guess once people make the assessment about what their data is and what's exposed, it might come down to a decision of, is it worth it? Like, I have this one issue area and it's a restricted transaction, and is it worth putting on all these requirements, or is it worth thinking of alternatives?
Yeah, no, that's what I said. I mean, companies have a couple different ways, and they can just say like, you know what, that's a good company, but the requirements are just too onerous, and it may make sense to go in a different direction and have a non-covered entity be reviewing that, or not have a foreign entity do it, or we're just going to lock down this data, just not make it available, even if it has some minor operational impact on one business unit, for example. So I do think that is going to be part of the analysis that companies are going to have to go through. This is not just cookie cutter, that there's one way of implementing one way of kind of getting to the outcome that you need. I think the analysis is going to drive where that ends up.
Yeah. And I'll just add too that the regulations go out of their way to distinguish these security requirements from whatever you might have in place at the outset, to make sure that you are not presuming that you are already compliant with these laws. So, for example, when the regulations define what constitutes bulk sensitive US data, it goes out of its way to say it does not matter if the data is encrypted, anonymized, de-identified, pseudonymized. These rules still apply to you. And the commentary sort of makes clear is that the concern is that although people may have these protections on their sensitive data already, the concern is that the protections aren't living up to CISA standards, right? So you still have to go through the analysis. You can't think it doesn't apply to me, my data is encrypted already. You have to go through the analysis and then do these security requirements. And as Brandon was saying, like, yes, like, congratulations, like, if what you already do matches much of which CISA does, then you're probably, well down the path to compliance. But it doesn't get you out of the regulations in the first instance.
And I'd also say that, having worked with a lot of companies, both in my government time and now, coming at it from the industry perspective, a lot of big companies do many of these things. I would say very few do them comprehensively, because it is hard. And having confidence that you have it in the right places is often a huge challenge. And so ensuring that you have this comprehensive set of security and privacy related requirements around systems where any of the sensitive data is going to be an undertaking. And I think every company is going to have to go through it, and they're going to find that they do have gaps. They would almost absolutely have some gaps in some of these areas. And there may be good reasons for that. There may not be good reasons, but I do think they're going to have to go through the analysis of being able to justify their implementation if DOJ comes and asks.
All right, should we turn to exemptions?
Yeah.
All right, so this is the part once you've done the analysis, you have the types of data that the rule is concerned about, you are transacting with it, and it's going to be a prohibited or restricted transaction. The sort of last thing you can do to think about is, do one of these many lists of exemptions apply? And again, there are a variety of exemptions, so we only have time to focus on a couple. One I think that's going to get a lot of attention is going to be the corporate group transactions exemption, or the intra-company transaction. And I think the important thing to take away from that is that there is an exemption if you are a US company covered by this regulation and you're making the data available to a subsidiary that is in a country of concern. But the touchstone is going to be whether or not you're making that data available ordinarily incident to and part of administrative or business operations. And then they give you a list of examples of what does that mean. And it basically boils down to HR, payroll, employee benefits, taxes. So it can't include core business functions. And the examples included in the rule do sort of flesh that out, right? If you are sharing financial information so you can pay a subsidiary who you've hired as contractors in Beijing, that's okay, right? Because you're sharing information for the purpose of payroll purposes. Same thing that if you're sharing fingerprints of US persons so they can get access to the building in Beijing or in other countries of concern, that would be appropriate. But the examples draw the line when they say if you're sharing financial data with your subsidiary in a country of concern, so you can help them develop financial software tool. No, right? That is a core business effort that is not ancillary to business operations and therefore would not be covered by this exemption. So again, I think just given the nature of multinational companies, there's going to be an instinct to want to point to this exemption, and that's the right one. I think that there's going to be a lot of time doing this entity by entity analysis, and then frankly doing that business analysis. How does this apply? And some of the ones are vaguer, like there's an exemption subcategory for risk management. And it is not clear what that means, and you can imagine people interpreting that broadly. So I think there is some wiggle room here, and this will be one of the more regularly invoked exemptions, but it will take a little bit of care and precision to understand what exactly is being transferred, what's the purpose for doing it. Brandon, you talk about documenting the purpose for doing that, and can we really make the case that it is, ancillary or administrative as opposed to a core business function?
Yeah, Joe, that's a good one. The other one that I was looking at was the exemption on financial services. I think this rule goes out of its way to ensure that this rule is not getting in the way of global financial transactions, and so it does carve out exemptions for, again, going back to the same kind of concept, transactions that are ordinarily incident as part of current payment processing, moving payments across borders, or central banks movements of funds, et cetera. So all of those are likely to be are exempt, but it does highlight kind of some of the subtle distinctions. So there was like two examples that I thought were kind of useful here, because they basically said, if a U.S. bank has made a payment, individuals in the United States are making a payment overseas, and you need to share information because of the movement of that money, that's okay. But if you are sharing information about a transaction that happens completely inside the United States, so between two U.S. parties, and there's information about that, sharing that with a third party overseas now is no longer exempt. So, I think companies, once again, it is not just what data is moving, it is why the data is moving and what was it for. And so again, it gets back to this rule is going to be, analysis heavy, because you're going to have to be able to document who was getting it, why it was shared, not in what data, but why was the data shared? Was it just incidental part of conducting business or a financial transaction, or was this for another purpose? Even though it may relate to an exemption, you will likely not, you're not allowed to claim that as an exemption.
Yeah, I definitely think that's one of the more complicated ones. I think there's also an example in there where it talks about the sharing of bulk sensitive data, but for the purpose of improving cybersecurity related to the financial transactions. And the rule said, yep, the exemption applies. And you're like, oh, okay, that's interesting. I'm kind of curious to what are the meats and bounds of that one.
I think if I was to say, again, it really gets back to those kind of founding principles, which is we're not trying to get in the way of kind of legitimate trade and financial transactions and businesses operating, but we're trying to keep very sensitive data outside of hands of people who don't need it. And if you need to complete a financial transaction, certain data needs to flow. But if two U.S. individuals are involved in a transaction, why is that data now moving overseas?
Like what's your nexus? What's your nexus?
What is the nexus? What is the connection to, if there's a clear connection, it has to be done there because that is the only place to settle that transaction. It makes sense. But if it doesn't, then why is it moving? And I think that you'll see that, I think, flow through most of the exemptions.
Yeah. And I think I can't remember what exemption it is, but there's another example about customer service centers. And if the customer service center is based in a country of concern and it has to do with transactions or, visits to the country of concern, then that made sense. But if you just set up your global customer service center in a country of concern, they're like, no.
No. Yeah.
All right, so the last issue topic before we wind down was implementation and compliance, which I think we've been touching on throughout because it's really hard not to. But Brandon, do you have any high-level thoughts about what does this mean for compliance programs?
Yeah, I mean, we've already talked a lot about, this is going to be, I think, a lot of work to get to a kind of compliance function. But there are some kind of key issues in here that you're going to have to do an audit to review annually restricted transactions and the company's procedures. Again, so not only are you going to have to do all that analysis up front, but then on the back end, you're going to have to conduct an audit to ensure that you were actually complying on any potential restricted transaction. There's a long retention period, 10 years for the implementation, the compliance related work. And I do think that it is the examination is going to be has to be comprehensive. The types of information they're collecting, the entities that they're selling or with whom they're sharing the information, the entities, individuals involved in data collection and processing. And I would say that if as a company is going through this, and I kind of touched upon this earlier, but I do think this is an opportunity for a far more holistic assessment of a company's both data security, data sharing practices, particularly their operations through, with, or potentially connected to one of these covered countries. I would not be surprised if this is not the last rule that comes out restricting certain business relationships and types of transactions with countries of concern, particularly China. I think that is a very bipartisan issue, and you could see further pushes here by the executive branch and Congress to clamp down even further. And so I think companies would be well pressed as they're going through this much work to begin with to think really carefully about is this an opportunity to review both their security, but also their programmatic operations related to data when it comes to any country of concern.
Yeah, I agree completely. I think that, sort of my observations about compliance programs, DOJ, says throughout, right, that they do not want to specify or require certain aspects of compliance programs. It's really going to be custom fit to who you are as a company, what is your risk profile. So they do leave a lot of wiggle room, so to speak. But that said, I think that the way we think about compliance too needs to be more comprehensive, right? We've talked throughout this conversation about like the different nodes, and obviously we're very focused on are you engaging in covered data transactions. But all along the way, right? Like if you're a US person, but you don't make your data available to anyone, or you don't make your data available to non-US persons, right? You can imagine worlds in which that changes, right? Like you acquire a new business unit and don't appreciate what they do, or you have a marketing team that decides to start monetizing some of the data that you've always collected, and you don't realize that you've gone from all US customers to that EU ad exchange, right? You've just incurred an obligation to include contract provisions, right? So it may not be a big lift, but it's having that compliance program earlier down the line to make sure that you catch these subtle shifts so little things don't become big problems. Right. So winding down, sort of like, what's next, what to expect. The things that I had on my list really centered around things that the DOJ promises in the rules and the commentary. So April 8th is the go live date. And DOJ has strongly suggested that they're going to issue additional implementation guidance. They've also, another factor or component of this program is the ability to issue licenses, both general and specific, as well as the ability to issue advisory opinions, which can be requested. On the licensing front, they did also suggest that they are considering, no promises, but considering issuing a general wind down license in recognition of the fact that people have a lot of work to do and maybe a lot of vendors to add contract provisions to, but none of this is promised. So I think that and the last part to that too is that the National Security Division of DOJ already has a voluntary self-disclosure program. And I think DOJ anticipates that this will be included in that too. So insofar as companies do find violations, especially if they're not the knowing kind of violations, right? You usually get credit for self-reporting those. So very curious to see how the implementation guidance comes out, what it addresses, what it doesn't address. And especially if there's going to be the voluntary self-disclosure program too, how that's going to be structured, because I think those will be important elements of figuring out how the rules apply, figuring out how compliance programs need to be changed, figuring out what you need to do.
Yeah, and I think all of those are going to, we've been kind of hinting at some of those along the way, things like additional implementation guidance. But I would say, when it comes to advisory opinions, some of these licenses, I think the sooner companies start to conduct the analysis necessary to figure out, do they have a problem at a scale where they may actually need to request a general license to wind down because it is complicated. The sooner they figure that out and be able to kind of go to DOJ and say, we've identified, a fairly long list of things we need to do that just won't be done by April, and we're going to need a license that gives us the opportunity to wind down, the better position they're going to be in. But I think DOJ is going to expect work if they're going to grant those. And so the sooner that work starts, the better, because there could be, companies could find that they've got a lot more work to do than they thought. And if they want to go to DOJ and get answers to questions or advisory opinions, or they're requesting guidance on specific areas, the sooner that happens, the better, because after April, they're going to be in a much more difficult position going to DOJ and asking for help.
And I'll just conclude by underscoring your prior point, Brandon, that this may not be the end of the road, not just for this program, which we expect to be many developments, but other programs. There's also a program that not a lot of folks are talking about, but there was a law that went into effect in June, the Protecting Americans' Data Against Foreign Adversaries Act, that the FTC is authorized to enforce. That law is live right now. We haven't seen any enforcement actions yet, but expect that to happen soon. DOJ said that they will be coordinating closely with them. Their law is a little more narrow. So I think, one way or the other, whether we're seeing enforcement actions on these programs, or whether we're seeing Congress and the executive expand their enforcement gaze, I think this is only the beginning of the story for the new regime of U.S. regulations on cross-border data.
Yeah, I mean, and you certainly don't want to be the one company that DOJ or the FTC wants to make an example of in either of these cases. And anytime you have a new rule like this, there's going to be the first one. So you don't want to be that one. And so I would encourage companies to kind of get started, because this is both important, and I think as Joe, you talked about, it continues to be a priority for DOJ. Well, that was good. I think we've covered a lot in the last hour.
Yeah, I'm impressed. Well, thanks, Brandon. Appreciate it.
No, thanks, Joe.
And I want to thank both of you from Berkeley, from the Berkeley Center for Law and Technology. I know this is volunteer work for you. You're giving an hour, 2 hours of your day to make this happen. So thank you very much.
Okay.
No, Wayne, thank you. Appreciate the opportunity.